Okay. Hello, everyone. My name is Kiana Hatfield, and I'm the program manager here at PAC. And today we have a session on life care planning with Nicki Applefield Engel from Collins Elder Law Group. And so she's here to just give you guys a presentation, and I'll let her introduce herself.
Great. Thank you, Kiana. Hi, everyone. So excited to have the opportunity to speak with you today. As Kiana mentioned, I am an elder law and special needs law attorney in Charlotte. I practice in the Charlotte area, licensed both in North Carolina and South Carolina, but mainly focused on North Carolina law. I'm certified as an elder law attorney by the National Elder Law Foundation, and the North Carolina State Bar has certified me as a specialist in elder law. And I've been practicing for about 11 years. I was in Asheville for a few years practicing there, most recently in Wilmington, and then have settled back in Charlotte, which is my hometown. I've got two young children under the ages of 3, and got my parents here, which is wonderful to have them close by. And that's one of the big reasons that I'm here back in my hometown. Today I wanted to take an opportunity to talk a little bit about life care planning and some of the legal documents that I think are absolutely crucial for everyone to have, but particularly for individuals who are dealing with chronic illnesses and disabilities that affect their ability to manage different aspects of life. So I want to talk a little bit further with you about that. I do have a PowerPoint presentation that I'd like to share with you. But before I go ahead and put that up, I do want to let you know that I'm welcome to take questions. I know sometimes people have questions and, it's hard to kind of wait until the end. You may forget what your question is. So please feel free to type into the chat box and Kiana will read the questions, and we'll take them as they come because your question may be really relevant to everybody else. If it's a question that's really personalized, kind of personal to your factual situation, I may, say, let's kind of pause for that, and we'll take care of that a little bit later. But again, just feel free, don't be shy. If you have a question, somebody else might have the same one. So without further ado, I'm going to go ahead and share my screen so that we can see the PowerPoint. And I believe Kiana is going to make this available to everyone as well after the presentation. Okay. All right. Can everyone see that okay? Can you give me a thumbs up? Okay, perfect. Perfect. So let's see if I can go to the next slide here. There we go. Just a few housekeeping matters. I did want to just mention that this is a presentation that's educational, and it's not really meant to provide specific legal advice. So nothing in this presentation should be construed as legal advice. If you feel like you need to have counsel on your particular situation, I'm happy to follow through with you on that, or recommend someone to talk to. But today, this is just meant to provide kind of general information. Viewpoints are my own, not the viewpoints of, the Parkinson's Association of the Carolinas. I do want to also remind everyone that laws are subject to change. So everything that we're talking about now is current law, but obviously things could change in the future. And again, if you do have questions, please feel free to reach out, and we can kind of take those as they come. I wanted to kind of start this with a little bit of a personal view and kind of give you an idea about how I got into this work and how I've seen it unfold. So I actually started my career as a public benefits paralegal for legal aid. And before I went to law school, I was working with a lot of older adults and individuals with chronic conditions and disabilities. And I was doing a lot of Medicaid and disability benefits cases. Really enjoyed those, just really enjoyed working with those populations, and felt like it was very fulfilling. So I've always enjoyed, working with older adults. And I also was very close with my grandfather growing up. So his name is Milton Applefield, and everyone called him Apple. But he was an incredible gentleman. He actually passed away at the age of 98 in 2013. But prior to his passing, he did have a diagnosis of dementia. And so our family did deal with that and saw the decline and, saw firsthand, how that can really affect, the ability to do things. And fortunately, he had put his legal documents in place. He had a durable power of attorney naming his son, one of his sons. So he had 4 boys. He was actually a World War II veteran, did a tour in the Pacific, did a tour in Europe, came back on the GI Bill, went to Duke University to get his master's in forestry, and then started a family. He had 4 boys, my dad being one of them. And of course, the sons kind of had different viewpoints and got along sometimes, didn't get along other times. But my granddad Apple was just had a zest for life. Honestly, he was just an incredible guy who's had a great sense of humor. He loved love, really. He was friends with everybody. He actually, married my grandmother and had 4 boys. She ended up passing and he got remarried, fell in love again. And then his second wife ended up passing. And then at the age of 92, he got married again. And so at that point in time, that was kind of a little bit around the time when dementia was being kind of thrown around and talked about. And, at that point in time, he had already done his legal documents. So he had a durable power of attorney naming one son as the agent to manage finances. And he had a healthcare power of attorney that named all 4 boys as the decision makers when it comes to medical care. He did not name his new wife, but he did later on pencil her in, which was actually not legally valid. But as his journey with dementia progressed, he did need to move from his home into an independent living retirement community, and then eventually to an assisted living facility. And that was obviously a very hard transition, specifically for his wife at the time. And there was a big struggle about the care and how that should happen. And we had many family meetings about, what decisions should be made. And, at one point in time, 2 of the brothers, my uncles, were considering guardianship, which is a legal arrangement whereby the court takes away your power to make decisions and appoints a guardian. And then the other 2 brothers were really wanting to honor my grandfather's powers of attorney and have those be put in place. So there was a bit of a struggle about the care, and eventually we were able to kind of work things out. But even with documents are be very difficult. Fortunately, my grandfather had a advanced instruction for a natural death, which is also called a living will. And so that really told the doctors and the family what kind of things that he wanted towards the end. And he was able to pass away naturally without having to be hooked up to a bunch of machines at the end. And that was what his wish was. So we were fortunate that he had those documents in place, and that really did impact me, and sort of make me realize that this is the area of law that is what I want to do and where I feel like I can make a difference. So I bring up this slide. We're not going to be talking too much about this in particular, because I do want to make sure that we cover the documents that are paramount to planning for life care. But I bring this, I want you to just kind of take a look at this, because it's important to keep this in mind. Now, this is obviously not everyone's progression, and this is very generalized, but this is what could happen and does sometimes happen. As we age, we sometimes lose the ability to do things, whether that's manage, the finances and pay the bills, or physically, manage to take care of things like dressing and bathing and things like that. And so as that happens, a lot of times we need more care. And if we don't, can't get care from family members, or it's to the point where, family members are not able to provide the care that we need, then, a lot of times we're looking at facility care or care in the home. And obviously, as most of you know, that is extremely expensive. The higher the level of care, the more money it costs. And, the more, we really have to think about how we're going to fund that. So this is not a presentation about funding long-term care, because that is a whole nother topic that we could talk on and on about. But I do think it's important to keep this in mind, because if care is needed, you have to have the right documents in place to protect your assets, to protect your family, and to protect your wishes. So again, we're not going to talk about all the various sources of funding of care, but it's important to have the right documents in place so that you can maximize your ability to fund care if you need it. So what is planning for incapacity? I really like this picture because I think it shows that, it really kind of shows us that, human beings are completely allowed to make bad decisions, right? And obviously smoking causes cancer, but people do it. Diabetics eat sugar, alcoholics drink. People can make bad decisions if they want to, and that does not mean that they're incompetent, and that does not mean that they don't have capacity. Planning for incapacity means that you need to put in documents in place to name somebody to make decisions for you if you're not able to do that anymore. But that doesn't take away your power to make decisions. So, even if you're making decisions that your family thinks are bad and are not the right decisions, that definitely does not mean you're incompetent. It doesn't mean that you, need to have a guardian. It doesn't mean that your power of attorney agent needs to kind of take over. So, I think we have to keep that in mind, and just remember that the law presumes that everyone has the capacity to make decisions. Until a court adjudicates you incompetent and says you can't make decisions anymore, you're allowed to make decisions, even if they're not the right ones that your family thinks you should make. What is the difference between capacity and competency? Well, capacity is really talking about the ability to perform a particular legal transaction. So capacity to sign a will, for example, means you need to know who your family is, what your property is, how that's going to pass under the will, essentially. Capacity to sign a contract means you need to understand kind of what's the nature and consequences of what you're doing. Now that can vary by circumstances, by timing, by the environment, depending on when you took your medications, that kind of thing. Capacity is not a black and white situation. Now, competency is sort of a broader assessment of your, complete ability to make critical decisions and manage your personal affairs, your life. And competency, where that's relevant, is if you lose competency under the law in North Carolina, you could have a guardian appointed. So, a guardian, again, is that legal arrangement whereby the court says you're incompetent, you're not able to manage your affairs, and we're going to, take away your rights to make decisions, and we're going to appoint a guardian for you. That is a last resort, and that is exactly what I want everyone to be able to avoid, because guardianship really is an extreme measure that should only be used if it's needed. And so if you don't have documents in place like powers of attorney, you're at risk for being under a guardianship. And I think everybody needs powers of attorney because of that risk. You just never know what could happen. So diminished capacity is a concept that we as elder law attorneys see all the time. Just because your capacity is diminished does not mean that you don't have the capacity to execute certain documents. It just means that we as attorneys need to be very diligent and very discerning in determining whether at that moment you do have capacity to do whatever legal transaction that you're trying to do. And these are some of the things that we're thinking about. Does this person appreciate the consequences associated with the choice? Can they give us reasons about why they're going to do that? Is it consistent with their, goals as we know them? Does that kind of reasoning make sense? And is it fair? So those are the things that we're thinking about when, we're working with someone with diminished capacity. And again, just because there is maybe a diagnosis of a mild cognitive impairment, or, it's the beginning stages of Parkinson's dementia, doesn't mean you can't sign documents and you can't, do what you need to do. It just means now is the time, right? Now is the time to go see an elder law attorney, to have the assessment done about capacity, and talk with them about what you want. I've certainly worked with many families where, maybe some of the family members come to me initially and say, oh, dad's, can't do it. There's no way. He's so forgetful, kind of going down that road. And then I meet with dad and I kick everyone out of the room. And, dad may have a little bit of confusion here and there, but ultimately he's okay, to sign a power of attorney. Now, on the other side of things, I've definitely met with clients, but it just, we're past that point, right? They were too far down the journey with that cognitive condition that it just really, we didn't have the ability to do that. But you never know until you try. So powers of attorney, what am I talking about here? There's really two kinds of powers of attorney that are absolutely crucial. One is a durable power of attorney. That's the document that names an agent to manage finances and make decisions about property, manage sort of your legal affairs. That's a really, really crucial document to have. And then the other piece of that is the healthcare power of attorney. And that names a healthcare agent to make medical decisions for you. And that document really only becomes effective when you lose the ability to make decisions for yourself. If you have the capacity to make your own medical decisions, they're always going to ask you what you would want. Now, the durable power of attorney can be drafted all kinds of different ways. Both North Carolina and South Carolina have statutory powers of attorney, meaning the legislators have come up with, forms that you can fill out. I don't really recommend that you use a form. I don't recommend that you use a LegalZoom or something like that. People do that, but, really it's important for you to talk with an attorney about, what you want and how you want things to be managed. What are your goals with regards to the management of your assets? Who are the players involved? All of that is really important to the attorney who's drafting that document, because that document should be tailored to you. It should be tailored to your situation. It should do what you need it to do. It should name the right people, who can be trusted. And so you're not going to that attorney just to get a piece of paper, or a document. You're going to them to be counseled on how that's going to work, and you're going to them for advice about, what is the best, document for you, and how is that going to help you in your particular situation. So, there's a lot of questions about durable powers of attorney that I see, who can you give the power of attorney to? So you can name anybody as your agent. You don't have to, it doesn't have to be your spouse. It doesn't have to be your child. Your oldest child doesn't need to be the first one. It can be a bank if the bank wants that. It can be a private fiduciary, bill paying company if they will allow that. Really, it's whoever you want to name. And who should it be? It should be the person or entity that's right for the job. So, I have people sometimes say, well, oh, this child is going to feel left out if I don't name them. And then I talk a little bit further about it with them. And they, I say, well, how's that person's credit? Do they have marital problems? What's their ability to manage things? And, then they start to say, oh, well, they've had a bankruptcy and they are terrible at, paying bills, and, that I don't trust their spouse, and, all kinds of things that would give you pause. So, the best way to answer who should that person be is, who is right for the job? Who is going to step in and manage your finances the way that you would want them to be managed? Why should you have a power of attorney? Well, I think we touched on this, but if you don't have a power of attorney, a durable power of attorney, and you lose your ability to manage things, nobody's going to have the authority to deal with your assets. So nobody's going to be able to pay bills. Nobody's going to be able to sign your tax return. Nobody's going to be able to get required minimum distributions out of your IRA. All kinds of things that you are doing on a daily basis that nobody has the legal authority to do. And ultimately, if that's the situation, then your family's not going to have any other option than get a guardianship over you. Can there be more than one agent? I think I talked a little bit about this with my granddad's situation. Well, for durable power of attorney, for both, I would strongly recommend that it be one person and then a successor and then one after that. A few reasons about that, especially for the durable power of attorney. There's a reason there's one CEO of a company, right? There's one person that makes the decision, and then, if that person's not available, it's the next in line. Dealing with banks, a lot of banks and financial institutions really do not like dealing with co-agents. That's when you have two agents. They definitely do not like if you have more than two agents. If you don't give multiple agents the ability to act independently, then both agents have to sign the check every time. They have to be there at the bank at the same time. I mean, practically, it's a nightmare. So yes, you can name more than one agent. I do not recommend it. It just practically is not a great way to do things. So what's the agent's responsibility? Well, the agent is a fiduciary, and we'll talk a little bit about that on the next slide. But what that really means is that they have to put your interest above all interests. So they are responsible to make sure that you have everything that you need, your property and money is being managed in the best way possible. They're liable for, any losses if they're derelict in their duties, if they're not doing the right thing, especially if they're stealing or doing something nefarious, they can get into a lot of trouble. But that being said, that's why it's really important to name the right person to be serving in that role. One thing I think is important to talk about is when does the authority end, but also when does it start? So durable powers of attorney can be drafted a couple of different ways. One, it can be effective immediately, meaning as soon as you sign that document, your agent's authorized to step in and manage things. There's no requirement that they go out to the doctor and get a note from the physician saying that you lack the capacity to manage your affairs. The other way to do that is you can have in the document that it is contingent on a doctor saying that you're not able to manage your affairs, that agent's authority doesn't actually start until that doctor's statement comes and accompanies that. I actually think that is not a great way to do things, because practically speaking, that agent has to get you to the doctor. The doctor's got to do the evaluation. They provide a statement, and then the agent has to take that statement along with the power of attorney to every bank. The bank's got to send it up to their legal department. It takes weeks, almost months to process it. And in the meantime, what's happening? Who's managing things? What happens if you get dementia and you refuse to go to the doctor? You dig your heels in and you say, I'm not going. Well, that power of attorney is useless. I mean, it's totally useless if you can't even get that doctor's statement. And some people say, well, what's to stop my agent from stepping in too soon if my power of attorney is effective immediately? And if that's the question, then I say, let's pump the brakes and let's talk about who this person is that you're going to be naming. Because if you think that the person that you are going to name is going to step in too soon or meddle with things or try to take control over the finances when you're still, paying bills and doing your thing, then that's not the right person. That is not the right person to be your agent. You need to have somebody who's going to work with you, who's going to do exactly manage things exactly the way that you would want them to be managed. And you got to be able to trust that person 100%. So, if that's the question, I think you have to rethink who the person is that you're going to be naming as your agent. Now, when does that authority end? So a couple of different ways that ends. So at death, of course, when you die, that power of attorney is no longer effective. The agent cannot, so much as even pay a bill after death. That's really not authorized. This is only designed to give the agent authority during your life. Another way that the authority could end is if you revoke the power of attorney, and you can usually revoke it by either signing a revocation document or by signing a new durable power of attorney that revokes the old one. So a couple of different ways that authority is going to end. So I think I touched on this, but I think it's important to remember that an agent is a fiduciary. And a fiduciary under the law, it's a legal term that basically means it's somebody who manages someone else's money for them. So if you're a fiduciary, you're stepping into a position of trust, and you're entrusted with someone else's property, and you're supposed to manage it for that person. There's certain things that you have to do. You have to act within the principal's expectation. So the principal is the person who signs the power of attorney. If it's your power of attorney, you're the principal. The agent obviously is the person that you name to manage things. So the agent has to know kind of how you like to manage things, and they've got to manage things the way that you would like them to be managed. If they don't really know that, then they have to act in your best interest. They have to manage your property more carefully, really, than they would manage their own. They have to keep really good records, and they have to keep their assets separate from your assets. So, there are some duties that are imposed on that fiduciary that cannot really be waived in that power of attorney document. Under the law, we want to make sure that if a fiduciary is serving, they're really going to be taking care of that principle. And so, these are the duties that can't be waived. And if they're breached, the agent can be liable and can be sued, essentially. And, it's a huge responsibility. And, you need to pick somebody who's going to be up for the job. So just wanted to briefly mention hot powers. I know that's a term you probably haven't heard, and that's really just a term of art in the elder law world. What hot powers are different powers in a power of attorney that are usually included to give the agent the ability to do asset protection planning in the context of long-term care. So when we're looking at our elder law or elder care continuum, you saw how there are different sort of puzzles, pieces at the bottom. And I'll actually go back to that because that might be helpful. So, in this continuum, as we age, we may need more care, and that care is expensive. These are the puzzle pieces here that are usually involved in paying for care. So it's private pay, Medicaid, sometimes VA benefits, things like that. Well, Medicaid and VA benefits and certain other benefits are needs-based. What that means is you have to have low income and assets typically to qualify. Well, if you lose the ability to move assets and utilize an elder law attorney's assistance with trying to qualify for a public benefit like that, then your power of attorney should authorize that. If it's important to you that all of your assets not have to be spent on care, and that you preserve some of those assets for your family, then your power of attorney needs to include the ability for your agent to basically do gifting, is what we call it. And gifting essentially allows the agent to move assets out of your name, give them to your spouse, give them to your children, and do it in a way that's going to allow those assets to be protected so that they don't have to all go, in the nursing home coffers. This kind of gifting should never be done without the advice of an attorney. And you really want to be working with an elder law attorney who understands the Medicaid rules, the rules about look back periods. You may have heard that in North Carolina and South Carolina, there's a 5-year look back. Well, that just means that when you apply, they're going to be looking through your finances for the past 5 years, and they're looking for gifts. Gifts are not the end of the world. Sometimes the elder law attorney is telling you to intentionally do some gifting to try to protect some assets. So I'm not going to get into the details about how that really works because we'll get into the weeds. But one thing I think that's important is if you're going to be going out and updating your power of attorney, or if you have one already, and you're curious if that's in there, look for gifting. Look for if there's a provision in there that allows the agent to do gifting. A lot of times it's limited by the annual exclusion for the gift tax amount, which is $16,000 per person this year. That really hampers your agent's ability to protect assets should you need a public benefit like Medicaid to pay for long-term care. Gifting powers are not for everybody, but if it's important to you to have your agent to have the ability to protect assets, you need to have something in there that addresses that. There are some other hot powers that are worth mentioning. The power to update beneficiary designations is oftentimes helpful. Let's say the wife loses the ability to manage things, but she's got a power of attorney. Well, let's say her husband has a diagnosis of Parkinson's dementia. We know that's going to be a progressive situation. Well, let's say we want to leave assets in a trust for him to protect those assets. Well, if we don't have the ability for the wife's agent to update her beneficiary designation on her IRA, that IRA is going to go to her spouse, most likely, if that's who she's named, rather than going to the trust for her spouse. So, building in those those flexibility is something that an elder law attorney is going to be asking you about. And, if it's appropriate for your situation, then some of those hot powers should be included in your power of attorney. Any questions on the durable power of attorney before I kind of pivot to the healthcare power of attorney? Okay. So, you also equally important are healthcare advanced directives. And when I'm talking about advanced directives, there's really kind of a few different documents that we include under that umbrella. One is the healthcare power of attorney. That's the document that names a healthcare agent to make medical decisions for you. There's something called the living will, which tells your doctors and your family what kind of end of life treatments you would want in certain end of life situations. For example, when is it appropriate to withdraw life support, that kind of thing. And then there's also the HIPAA, which I'm sure you've heard of, but that's really just an authorization that names people who can have access to medical information. It doesn't give them decision-making power, but I think that's helpful to have as well. But let's talk a little bit about the healthcare power of attorney. So what happens if you don't have one? Under our law, there's a default. Of course, our General Assemblies come up with a situation of who makes a decision, and it's your spouse. But if you don't have a spouse, then it's a majority of your reasonably available parents and children. And some of you are probably thinking, well, that could be a nightmare, which it definitely can. And so, long story short, healthcare power of attorney allows you to have a voice at a time when you don't have one. So, rather than defaulting to the statute, you can name somebody who's going to be the one to make those decisions. You can name a backup, and you definitely should name a backup in case that first person's not available. So we kind of touched on that already. I think there's one more advanced directive that I just wanted to mention briefly, and that's a psychiatric advanced directive or an advanced instruction for mental health treatment. That is like a living will, but for psychiatric care. And so typically that's going to be helpful to someone who maybe has had some inpatient psychiatric hospitalizations or has had a lot of different treatments over the years and knows that if they're in a mental health crisis, they want particular things or they do not want particular things. That document can be extremely helpful for that sort of situation. But the healthcare power of attorney, generally is going to be the best thing to cover most people's needs. And so it really gives your agent the authority to make any decisions you could make. Now, you can limit that authority in any way that you want. So if you've got particular beliefs about certain treatments or, there are certain things that you want or do not want, you can spell it out in that document, and you should. The other part of this is making sure that your healthcare agent knows what you want, and that's through conversations with them. And so that's really kind of the under the umbrella of advanced care planning. So advanced care planning is really that conversation, that ongoing conversation with family, with your healthcare agent about what you want. Maybe, at age 50, there are certain things that you don't want, and then at age 80, there's other things, that you don't want. So as we age, as we change, as we evolve, our beliefs and our values may change. And so that ongoing process is important. And, you may need to update your healthcare power of attorney as you change your mind on things. Who should be named as an agent? Well, you want, again, the right person for the job. So who's going to be the one who's going to be able to make that hard call? If it's an end of life situation, is that person going to be able to stand up to their siblings who are in their ear about what mom, would have wanted? Is it somebody who's going to have a cool head under pressure? Is it somebody who's going to be able to take all the information from all the various different doctors and synthesize that in a way that they can make an informed decision about what you would want? The way that they should be making decisions, they should always think about what would the principal want? So it's not, the healthcare agent doesn't make a decision about what they think is best for the principal or how they would decide if it was up to them. It's really, they need to step into your shoes and make the decision that you would make. And so obviously they need to know what kind of things you would want or what kind of things you wouldn't want in order to make that decision. Healthcare power of attorney has to be signed in front of 2 qualified witnesses, which means that they can't be family members. The witnesses can't be people that work in a facility or provide any kind of medical care to you. And so that can be kind of difficult sometimes. I do a lot of meetings with folks in their homes and in facilities and in hospitals sometimes. And if we're signing a healthcare power of attorney, we can't just grab a nurse or grab, somebody from down the hall, to be that witness. So it's important, if you're going to be doing this document, just remember that it has to be 2 witnesses that are not related to you, that aren't providing you any kind of healthcare, basically people that don't have any sort of stake in the game. And it also has to be notarized. So really important that you have to have that notarized. I did just want to mention a DNR and a MOST form. So you may have heard of these forms. So a DNR is a do not resuscitate order. A MOST is a medical order for scope of treatment. Both of these are doctor's orders, and they are not something you get from the lawyer. They are helpful for individuals who have chronic conditions or, are very elderly and frail, or have, terminal illnesses. And those are really designed to make sure that, that person's treated humanely as, they come to the end of their life, that there's not sort of last ditch efforts to try to save that person if that kind of treatment's going to cause them more harm than good. So that, kind of goes in conjunction with the healthcare power of attorney, but it's really not something that they're going to give to anybody who is, not, in that situation where they're sort of towards that end of life or terminally ill type situation. So before you sign the document, you definitely want to talk to your friends, talk to your family, talk to the people who you're going to name as your healthcare agents. Talk to your rabbi, your priest, your spiritual advisor. Make sure you understand that, how you should kind of be filling that out and what kind of things, you want to put in there so it's consistent with your value system. And then again, make your desires known. So, it's great to have the document, but if nobody, knows what you want, then it makes it that much harder to make that critical decision when it comes time to do that. The person that you appoint, you got to make sure that they're willing to follow through. I remember I worked with a medical ethicist one time. She was an ethicist at a hospital, really interesting woman, and she had a healthcare power of attorney, and she did not name her spouse as her healthcare agent because she knew that her spouse wasn't going to be squeamish and was not going to be able to make that hard decision if, for example, she was in a persistent coma and was on life support. She did not want to continue in that situation, but she knew her husband wouldn't be able to, if you will, make that decision about to pull the plug, that kind of thing. So, who you name has got to be the person who's going to follow your wishes. Again, this is an ongoing sort of process. And so if your mind changes, you got to change your power of attorney, your document so that it reflects what your current beliefs are. And I touched on this, the advanced care planning process is a process that involves you and your family and your trusted, friends, as well as your doctors, your doctors and the people that you trust on your medical team. That conversation is an ongoing one. And, there are situations that as an attorney, I can never contemplate every kind of medical situation that could possibly come up. So I think it's really helpful for you to talk with the medical team, about those certain kinds of scenarios and what kind of, artificial means are going to be used in this kind of scenario. And what does that mean? And how does that affect your quality of life? And, to have that conversation is going to really help guide you in making decisions about how to craft your own healthcare power of attorney, your own living will. So just kind of in summary, I just wanted to say that, having powers of attorney in place, incapacity planning documents is absolutely crucial. That allows you to have a choice when you otherwise do not have one. It allows you to have a voice when you're, not able to express yourself and communicate. It protects your family against, future conflicts because they don't know what the heck you wanted and they don't know, how you want things to be done. And it really just allows you to be able to have that autonomy to make decisions about your own life in a situation where you're not able to do that. So that is all that I have as far as the substantive material. I did just want to put up the last slide with the information about how to get in touch with me. If you do have questions that you're not comfortable asking today, please feel free to email me or call, or if you're interested in updating your documents or speaking about long-term care or, learning about Medicaid, anything like that. I'm happy to have a consultation with you and we can certainly dive deeper, if needed.
Does anyone have any questions for Nicki? And you can come off of mute at this point. You don't have to use the chat box function.
I have a question, but I can't find the chat box to type it in.
You don't have to type it.
This is Cindy, and I have a cold. I'm sorry I sound so hoarse. I have the advanced directives and a living will, but do I need an elder care attorney also, elder law attorney?
Well, that's a good question. So I would say it definitely depends. If you look at your documents and they name the right people. So if you have a healthcare power of attorney and it names the right person and you've got a backup and you've got your living will and that memorializes your wishes as they are today, you may not need to update that. It's not a bad idea to consult with an elder law attorney and just have them review the documents. That way, they might see things that you haven't thought of. They might ask questions that you haven't, been asking. So, it really depends. I think particularly the durable power of attorney is one that you probably do want to have reviewed by an elder law attorney, because that one is a little bit, more focused on, making sure your agent has the ability to plan for, long-term care, that kind of thing. So, it depends. I would take a look at your documents, make sure you've got the right people in place. And again, it's not going to hurt, I don't think, to consult with an elder law attorney, to review them and to ask questions so that, you can really feel confident that what the documents say, are appropriate for, meeting whatever objectives that you have.
Okay, thank you. That answers it.
Good.
Thank you.
I have a question if there's still time.
Sure.
Okay, so my husband with Parkinson's, he also has the Parkinson's dementia. We're assuming it's the Parkinson's dementia, or it could be the Lewy body dementia, because he's had the DBS, so they don't do the MRIs because of the probes in the brain. I have all of the documents that you talked about, just like Cindy. They were done from our regular lawyer, our family lawyer, but he's had it for like over 20 years. And currently I'm healthy. I hope I'm healthy. But what I've actually just started worrying about, and I'm in the process, I'm from Maryland. Okay, I'm just down south in the summertime. I mean, in the wintertime. Is what happens if something happens to me. Now, we have like the power of attorney and we have the people identified, but so if I know that his children do not want to like care for him. And I know that sounds really harsh. My daughter has offered to take care of him if something happens, and she would want to follow his wishes. So do those wishes have to be identified in his power of attorney? Or is there something that should trigger it in one of my documents if I die?
So that's a good question. It's going to be in his documents. So if you die before him or you become incapacitated, there should be a successor agent, a successor under the durable power of attorney and a successor under the healthcare power of attorney. And if he doesn't have those, then then you may be in a situation where guardianship would have to be put in place. So I would look at the documents and see who he's named. If that needs to be changed, he may be past the point where he can sign, he may not be, it just depends on, a lot of things. And that's where you want to really talk to an elder law attorney about that. But yeah, it's going to be according to his documents. So, if you're out because for whatever reason you're not around, it's going to default to the next in line. And if that's one of his kids, that's probably not the right person, right?
Yeah, so I've been reviewing the documents, and the healthcare power of attorney, when he did that, he has, like you say, the squeamish children or whatever you want to call it.
Yeah.
And at that time we named someone so I know that document has someone backing me up.
Okay.
But on the, so then he would need someone backing him up on the power of attorney. Is that the one that he would need?
Yeah, the durable power of attorney.
Durable power of attorney. Okay.
Okay.
So, and that's the durable power of attorney. Is that different than a financial power of attorney?
It's the same. It's the same.
Okay. All right. Okay. Thanks very much. And I think I'm getting all this done in Maryland because that's where we pay our taxes.
Mhm.
So I guess I have to have it done in my home state.
Yes, yeah, it's going to be the state where you reside, which there are elder law attorneys up there. So the best way to find one, I think, is to go through the National Academy of Elder Law Attorneys website. And that's, we call it NAELA. So it's NAELA.org. And you can go on there and find an attorney. If they're a NAELA member, that means that they're definitely more honed in than just an estate planning attorney that says they do elder law. So that'd be probably where I would start to find somebody in your area.
Okay, thanks. It's been very informative. Thank you.
Good, you're welcome. And I see there's a question in the chat. I'm just gonna go ahead and read that one if we have time, which I think we do. So this just says, I'm curious about the hot powers of a DPOA, a durable power of attorney. We already have trust in place, and does it still have to be spelled out in the DPOA to be able to protect assets? So that's a great question. I think, yes, you should have that ability in the durable power of attorney, as well as it should be addressed in the trust. So the trust is only going to cover what assets are in the trust. And certain assets are never put into the trust, particularly IRAs. So individual retirement accounts, any kind of qualified retirement account, you don't put that in your living trust because that's a taxable event. And so that the durable power of attorney is the document that allows the agent to deal with that. So, there are other kind of assets that may need to be dealt with through the durable power of attorney. So I think it is important to have that both in the durable power of attorney as well as in the trust, because the trust is going to cover the trust assets and the durable power of attorney is going to cover everything else that may not be, under the trust. Okay. Great. Any other questions from folks? Anything about the healthcare advance directive or anything we've talked about so far? Well, thank you so much for your attention. Again, I think Kiana is going to send out the PowerPoint PDF version of that, so you'll have that. My contact information is on there. If there's a question that pops up that you think, oh, what was she talking about that? Or, I forgot to ask this, please feel free to reach out. Email is probably a faster way to get an answer, but you can always call. So again, appreciate your time and the ability to come and provide a little bit of education today.
Thank you.
Okay, well, Thank you, Nikki, for such a lovely presentation. And so as Nikki mentioned, I am going to post the PowerPoint on our website, and this session recording will be on our YouTube page, hopefully by the end of the day tomorrow. So if you want to refer back.
Great.
But thank you all for joining us today. I hope you got your questions answered, and feel free to give us a call if you have any questions, or give Nikki a call or email.
Great. Thank you. Take
Thank
care.
you.
Bye, everyone.